All right, we're about 2:04, so I think we're going to get started. Some other people may be popping in and joining us. As we get started, I'm going to ask everybody just to mute themselves during the presentation part, and I'll explain in a moment how we'll do some questions via chat, and then at the end we can take everybody off mute and have an opportunity to participate. But that way it will reduce the risk of interruption if we put everybody on mute. So thank you. And I'm just going to give everybody till 2:05 so everybody's in and the clock turned. So welcome everybody. Today's topic is hot topics in labor and employment law, what employers need to know, and our 2021 edition. I can tell you that in my career as a labor and employment lawyer, the last 12 months have probably been the most dynamic. We've had a lot of changes in the law. We've had a lot of new issues arise, and it's always changing. So the law has changed probably more recently, and new topics that many of us have never encountered before. So there are a lot of hot topics. We're really going to focus on a few today, although we have some additional topics to get to as time allows. Krista, if you'll advance my slide to my agenda slide, I can go through that with everybody. I'd appreciate that. So we're going to start today talking about vaccine protocols for the workplace. This is a topic that there's a lot of confusion about, rightfully so, because we have a lot of confusing messaging, both from the federal and state government. So we'll try to wade through that and give you some pointers and best practices for the vaccine protocols for the workplace. We were also going to transition and talk a little bit about COVID-19 leave. We've talked about this a lot. If you go to our website, you'll even find a number of FAQs on this, but we really haven't talked about it nearly as much since the start of the pandemic. And with some recent changes in the law, there are some new things that employers do need to know. Next, we're going to talk about incorporating the changing cannabis laws in employment policies. This is big in New Jersey. We've really had a significant change to how employers can and should be handling cannabis issues in the workplace all of a sudden. So I want to make sure everybody's up to speed. And what we'll do is go through the latest law, but I also need to explain, and we'll talk about this a little bit, that there are cleanup bills that have been proposed that would potentially change some of these things. We'll talk about where things stand now. We're going to talk about addressing off-work conduct of employees. This has become a hot topic, especially since the January 6th siege in the Capitol, and what rights or responsibilities employers have with respect to handling employees who engage in lawful off-duty conduct that an employer finds offensive. And then we will be talking about managing a remote and semi-remote workforce. If we have time, we'll talk a little bit more about how to, in that context, how to bring people back and some of those issues that everybody's facing as we are starting to transition out of full remote work and more into either semi-remote work or full in on-site work. If you'll advance to my next slide, I'd appreciate it, Krista. This is just a disclaimer, obviously this is general information. It is not legal advice. We're not creating an attorney-client relationship. So I hope everybody understands that. I also want to point out that for those of you who need it, the webinar has been approved for Pennsylvania, CLE, HCRI credit, and SHRM credit. And then attorneys, we just need you to email your PA bar number to marketing@flastergreenberg.com. Again, marketing@flastergreenberg.com. It's up on the screen. This will also be recorded, so I want everybody to be aware of that. And if you send an email also to marketing@flastergreenberg.com, we will share the slides with you. We're going through some of the aspects of this may be technical, and you may want to reference the slide deck, and we'd be happy to share them with you. For HR professionals who need certificates of attendance, again, just email marketing@flastergreenberg.com. One email address solves it all. So with that, let's get into the substance of today's presentation. And as I promised, we're going to start with vaccine protocols. And one of the first questions that is facing employers is, may I use a mandatory vaccination policy or introduce a mandatory vaccination policy? And we have a lot of confusion on this, and I'll start sort of why there is some confusion. The New Jersey Department of Health put out guidance that really does appear, at least on its face, to endorse the idea that employers could have a mandatory vaccination policy for on-site work. That would mean that employers could require people to be vaccinated to do on-site work. It does not endorse the idea that somebody who is not vaccinated can be terminated from their position or even necessarily denied access to the workplace. It's vague on those issues, and I'll get into a little bit why I have some concerns and what I think the best practices are. At the same time, the EEOC at a federal level, and to be clear, this was the EEOC under the former administration. So the Biden administration EEOC may issue some different guidance, but under the former administration, the EEOC guidance also appeared to endorse the idea that employers could require vaccinations. However, it also incorporated the emergency use authorization law into it. And the emergency use authorization law provides that employers, or pardon me, that any individual has a right to refuse an emergency use authorization only vaccine. Now, by way of context, that provision in the emergency use law is really meant to refer to mandatory government vaccinations and to ensure that the government isn't using, governments aren't using an emergency use authorization to mandate vaccinations. However, it also creates some concerning issues for employers and some concerning risks, as does the New Jersey Department of Health guidance, which does, again, appear to allow mandatory vaccinations. Before I get into some of my concerns about that, I should also tell you that no matter what, even in the New Jersey Department of Health and EEOC view, every employer must allow exemptions based on medical conditions and religious beliefs as they can reasonably accommodate them. So if you do have people, you do opt to have a mandatory vaccination program, you really need to think about how you're going to handle exemptions for folks who have medical conditions that prevent them from being vaccinated or deeply held religious beliefs. Those are important exemptions that you need to consider before you introduce a policy so you know how you're going to handle it. Additionally, you'll see a bullet point there that says employers should stay away from conducting a medical examination. When an employer conducts a medical examination of an employee, they're held to a different standard and it creates potential liability. And so for that reason, employers should not be taking medical history and the kind of information an employer would, or a healthcare provider. I'm sorry, whoever's speaking, can I ask you to please mute yourself? Thank you. Appreciate it. So employers do need to be cautious not to actually conduct what's called a medical examination. And you can avoid that by using a third party to administer the vaccine, by having a mandatory vaccine policy that just requires people to go to, to a mega site or a pharmacy. So this is probably only an issue for employers in the healthcare arena where they could potentially administer the vaccine themselves. And if you're going to do that, you should definitely consult counsel because there are some specific ways in which you should structure that so you're not eliciting medical information from your employees and recording it and maintaining it, because that can create additional liability. But let's zoom out. And we've sort of talked a little bit about what the Department of Health says and what the EEOC says, but I think practically employers should be concerned about two things if you're going to mandate vaccines. We have a number of people in this country who are concerned about or resistant to getting the vaccine. and most employers are not mandating it. In fact, very, very few are, even in healthcare at this point. So if you were to adopt a mandatory vaccination policy, I think you really need to consider how that could potentially affect your ability to retain talent. Are you going to lose employees that you care about? And so I think that's a real issue and a concern, especially if your competitors are not mandating vaccines, which is likely the case currently. I also expect, and I know from my discussions with my counterparts who primarily represent employees, they are expecting to mount challenges to mandatory vaccination, especially outside of the healthcare setting, as to whether it's appropriate or necessary. So you do create a degree of liability, and you, at this point, I think you'd be on the bleeding edge if you are mandating a vaccine. It's not to say you can't do it. It is to say that it does come with some risk currently. At the same time, I think employers are understandably concerned about how we encourage and vaccinate our workforce, right? I mean, we want that. It's good for the business. Hopefully, it's good for the individuals. And so one option is incentives. I would encourage employers who are encountering vaccine resistance to consider incentives, whether that's monetary incentives, paid time off. Some have considered, and I think this is sort of on the table but premature, the idea that folks who are vaccinated may have more relaxed PPE requirements than folks who are not vaccinated. That's traditionally been done in a hospital setting for the flu vaccine. If you're not vaccinated, you need to be masked all the time. Right now, that's a very hard thing to accomplish because we all still have to be vaccinated in the office. Masked in the office or masked in the workplace anyhow. So drawing that distinction is not really a viable option in most workplaces now. But it may become one, and something to keep in mind too, to encourage vaccination. Again, remember, if you're going to use an incentive to encourage vaccination, you need to think about an alternate incentive that is, on par with the incentive you're offering for folks who cannot receive the vaccine due to medical conditions or deeply held religious beliefs. I'll say that typically I recommend some sort of safety-based incentive. They would take part in, or be a safety officer, take part in some sort of safety-related activity to justify that benefit. And so you do need to think about and communicate, when you do communicate the incentive, that there are alternate incentives for folks who cannot be vaccinated due to medical conditions or religious beliefs. And again, barring employees who are not vaccinated from the workplace, especially if they're jobs that cannot be done remotely, really brings a host of complications, and a host of complications that I expect will be litigated very seriously. So, know the risks, consider the risks, think about the market, and you got to decide what's right for your business. We're going to move on from vaccines to our COVID leave section. And this slide is sort of the original recap of FFCRA, which was the Families First Coronavirus Response Act. If you'll recall, this was one of the first big acts by Congress to try to offer paid leave to people who are affected by COVID, and offered some other benefits. But the paid leave benefit was really the most significant for employers, at least vis-a-vis employees, separate obviously from the PPP and things like that came out of the CARES Act. And if you'll recall, FFCRA leave, and there are three sort of different categories of leave. One for people who are sick or being diagnosed or have to quarantine. One for people, my middle tier, for people who are caring for somebody who's sick or has to quarantine. And the third for people whose parents, whose children's place of care is closed and they can't telework. So this leave was really designed not for people who could work from home, but for people who could not work from home. And it had specific pay rates: $511 if it's your own illness, $200 if you're caring for somebody, and 200 if you're caring for somebody else a day, with aggregate caps. As many of you will recall, the FFCRA mandatory leave expired the end of 2020. So you may be wondering, well, why are we talking about it? And then we'll get to our next slide. But I just wanted to give you a sort of basis for what we're going to talk about next. So FFCRA leave is now optional. It was originally optional through the first quarter of 2021. It has now been extended through the third quarter of 2021. So that means that employers who are eligible to offer FFCRA, and that is employers with 500 or fewer employees, large employers don't get this benefit or don't have to offer it, but also don't get the tax credits. You would get a payroll tax credit if you do offer FFCRA leave through September 30th, 2021. I can't tell you whether it will be extended for the rest of the year. I expect that will in part depend on the status of the pandemic as we move forward. But the payroll tax credits are now available through the third quarter. And to explain the payroll tax credits, essentially whatever you owe to the government in your payroll taxes, when you make your quarterly payroll tax payment, you get a dollar for dollar credit for approved FFCRA leave that you paid employees. So in a certain way, it is pass through money from the government. A couple of other changes that have been introduced for the 2021 optional version of FFCRA leave that I do want to point out. Covered employers can now offer leave for getting vaccinated and for dealing with the side effects. That's important and ties into our first topic. One thing you can do to incentivize people to get vaccinated is to let them know that they will receive paid leave up to the caps that we discussed in the previous slide for getting vaccinated and in the event that they have side effects. So that is an important change. Additionally, benefits renewed as of April 1st, 2021. So if you had folks who exhausted their FFCRA leave but now have a qualifying leave reason, you have the option to treat them as renewed and still take the tax credit. The maximum tax credit's been increased to $12,000 an employee. And the final bullet point, and this was new, obviously it didn't really affect FFCRA when it was mandatory for everybody, but there is now a non-discrimination requirement, meaning that you cannot offer paid FFCRA leave to your executives, but not your line people. It really needs to be offered consistently throughout the organization, and you can't treat or offer a greater level of benefit to your higher paid employees and still expect a tax credit. My last bullet point, I just want to remind everybody, paid time off, FMLA, and New Jersey Family Leave Act for our New Jersey employers here, and unpaid leave are also options for COVID leave. Somebody needs, COVID leave, you can either take it out of their paid time off as you would, assuming it's a serious health condition, they would fall within, and they're covered by FMLA. They may have FMLA benefits, and they may also have New Jersey Family Leave Act benefits. Quickly, I will just remind everybody that one of the differences between New Jersey Family Leave Act and the federal Family Medical Leave Act are a little different. First, New Jersey now applies if you have 30 employees, whereas the federal applies if you have 50 employees. Second, one of the other important distinctions, and it's material, is that you have federal FMLA rights if you are sick or you're caring for a sick family member. New Jersey Family Leave Act only applies and only offers you leave if you're caring for somebody else's illness. If it's for your own, you don't qualify for New Jersey Family Leave Act. You still qualify for mandatory sick time, PTO, and other benefits, and potentially disability benefits, and you're still protected by disability discrimination laws. But the Job Protected Family Leave Act is under New Jersey law is not available.
She comes to drop off.
I am not seeing questions in the chat, but everybody's welcome to join them. And I hear somebody talking, and I'm just going to ask that everybody mute themselves so we can continue. I appreciate that. We're going to move on from talking about COVID and sort of some, obviously dark things to maybe happier things. We're going to talk about cannabis and how that's changed in the workplace. As Carl Sagan said, the illegality of cannabis is outrageous. An impediment to full utilization of a drug, which helps produce the serenity and insight, sensitivity, and fellowship so desperately needed in this increasingly mad and dangerous world. Whether you agree with that or not, I think the important thing to recognize as an employer is that not only have cannabis attitudes changed, but cannabis laws have changed substantially. Crystal, will you advance me to my next slide? Thank you. So the newly passed, this is going to be a mouthful, the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. We're going to call it NJ CREMA for short, although it's not that short. But it does change the landscape for employers, both in concrete ways and in ways that are still evolving. And that's something I alluded to in my introduction, that we're going to tell you what you can and can't do today, but I think you need to keep an eye on this because there are some significant potential changes and reforms here that would likely grant more leeway, not less, to employers. So we'll get into that right now. NJ CREMA says, no employer shall refuse to hire or employ any person or shall discharge from employment or take any adverse action against any employee with respect to compensation, terms, conditions, or other privileges of employment because the person does or does not smoke or use cannabis items. So this is different than the law had been. The law previously had protected employees who were registered as part of New Jersey's medical cannabis program. Interestingly, a really close read of the law under the medical cannabis law said you couldn't discriminate against somebody because they had a card. It didn't say that you couldn't take an adverse action because somebody tested positive. So in other words, you couldn't figure out that somebody had a card and fire them, but you could fire them for testing positive even if they had a card. The law did require you to give notice that there was a positive cannabis test and at least give an employee an opportunity to present the fact that they had a card or were lawfully using it under state law, but it didn't require you to accept that as an excuse for a positive test. That's very different. Now it's saying just because somebody uses cannabis, you can't base an employment decision one way or the other based on a positive test. So it almost says there's no reason to screen for cannabis now, and we're going to get into that in the next slide, which was just previewed a moment ago. So let's talk briefly about what you can still do. Employers can maintain drug-free workplace policies applicable to federal contractors and other government vendors if they're required to do this. You can and frankly should implement discipline for impairment, and you can take steps to ensure the protection of employees and the public in the same way that employers have historically done those things. But what you can't do is what's new. More things employers can do. You can go back to, if you would go back a slide, Kristen, for me. I'm just going to make sure everybody understands this. You can conduct employee drug screenings for drugs other than cannabis. You can conduct suspicion-based testing, but we're going to get to that in a second because there's a big caveat there. You can investigate suspected use. You can prohibit possession on company grounds, prohibit use during work, prohibit cannabis use to the extent it may disqualify you from a federal contract. So to the extent that any of you have federal contracts, that is probably the biggest exception to the cannabis law here, is that, to the extent it's going to impair your federal contract, specifically, we're seeing it in some defense contracts, you have more rights, and you can discipline employees for impairment at work. So these are all the things you can do. Now we'll get to the things you cannot do. You can't discipline employees for testing positive for cannabis without evidence of impairment at work. This is new, right? The previous view of this was cannabis is illegal at a federal level. Employers have a lot of discretion to discipline or terminate or take adverse action against employees who test positive, even if their use is lawful under state law. Some of you may be familiar with this even from as sports fans. The National Football League would not allow players to use cannabis or test positive for cannabis, even if they played in states where it was lawful or used it in states where it was lawful. And the NFL's take on that was really quite similar to many employers. Now for New Jersey-based employers, that's no longer going to fly. You cannot refuse to hire or discipline an employee for cannabis use outside of work. That means an employee can come in and discuss or talk about their cannabis use, just like they would talk about going to the bar or having a drink, and there's nothing you can do about it. And you also, and this doesn't come so much out of the NJ Crema, but under a New Jersey Supreme Court case from earlier in 2020, you cannot refuse reasonable accommodations for employees who lawfully use cannabis medically. And we'll talk a little bit about that the law on that is really still developing. There are strains of cannabis that are supposedly that have low psychoactive properties, which would potentially mean that an employee can use it without being impaired at work. And there are questions, it's yet to be resolved whether employers, if there is no impairment, can terminate for use at work when somebody has a medical reason. That clearly wouldn't apply to somebody who has no medical reason for using it. If somebody has a medical reason, that's a little bit of a gray area that's evolving. You'll move on, Krista. So we've touched on this, but haven't really explained it in enough detail, so I want to. I call this the test plus requirement under NJ Crema, and this is the reason that testing is going to become so complicated. And the real issue here, I think, that the law is trying to grapple with is the fact that the science has not caught up with the law. So we don't have a test currently that can test for impairment, like a breathalyzer test for alcohol, for impairment from cannabis. So the fact that an employee tests positive for cannabis does not necessarily reflect that the employee is impaired at work. They could have easily used it lawfully under New Jersey law in a non-work setting and not be impaired at work and still test positive. So the law tries to address that in really a quite unique way. It requires that the employer, in addition to having a positive test, if that's what you're going to rely on, also conduct a physical evaluation to determine whether the employee is impaired before you take action based on a positive test alone. Moreover, there has to be the physical evaluation has to be performed by someone certified as a workplace impairment recognition expert. Now, I'm sure many of you are asking the question I asked when I saw this is, what is a workplace impairment recognition expert? How do you become one? Where do you hire one? And the answer to that is we don't really know. The Cannabis Regulatory Commission has to come up with the guidelines for the training. It hasn't done that, hasn't developed them yet. But it will, unless we see regulations that change it. And then this is the odd sort of aspect of this. Until that happens, there's language in the NJ Crema law that says it's not considered operative. Parts of the law that are contingent on the Regulatory Commission issuing guidelines aren't operative, even though the law is deemed effective immediately. All of that sort of put together in a practical sense means that employers are well advised not to use a positive cannabis test as a basis for an adverse employment action. There are other options that I think are favorable to that and create a lower risk of liability. And we'll be getting to that next. Sorry, I was just looking at this slide. Before I get into legal off-duty conduct, I want to discuss briefly what those options are. And that is to say that employers have been on the lookout for impairment since they started employing people, right? You still have to be concerned about the employee who's drinking at lunch lawfully, who is using prescription drugs, even if they are lawfully prescribed for the employee in a way that impairs them at work. For the employee who just doesn't get enough sleep and is sleepy at work, you're looking for performance issues all the time. And I think the best and safest approach for cannabis under this new regulatory scheme is to continue to look for signs of impairment and treat the performance issues. Somebody was asleep at work, somebody was forgetful, somebody didn't do their job, as disciplinary events and discipline on that basis. Obviously, you can also be on the lookout for possession at work, use at work if you see it, things like that as well. But I think that a lot of the concern I'm hearing about the not being able to rely on tests is ignoring all the great experience employers have with identifying employees who are struggling to perform, and that should be the basis of disciplinary action. Moving on from that, I want to touch on legal off-duty conduct. Now, this question really has arisen largely from the siege in the Capitol, which is what I mentioned earlier. And you can even see as you go to my blog, adamgersh.net, or our Flaster Greenberg website, which links to my blog, you'll see we actually have put up an article about this particular issue and exploring it because it has become a hot topic. And it's not just about the siege on the Capitol. It's really about how can an employer discipline an employee for off-duty conduct. Now, interestingly, New Jersey does not offer unlimited protections for lawful off-duty conduct, but its protections are pretty limited. We just talked about the fact that employees are protected from cannabis use off-duty, meaning you can't fire somebody for using cannabis. They're also interestingly protected with some exceptions, especially for healthcare industries and advocacy groups, for use of tobacco off premises and off duty. So, unless you're, an exempt organization, you can't refuse to hire somebody because they are a smoker. You can, if you use smoke breaks, you can ban smoking in the workplace, on campus. You can discipline somebody for smelling like smoke if it's, noxious. But you can't actually just fire somebody or discipline them because they happen to be a smoker. Cannabis sort of follows that earlier model. But interestingly, in New Jersey, we do not have a lawful off-duty conduct law. For instance, in Colorado and certain other states, there are such laws. And those laws are really meant to protect employees who engage in conduct that might be controversial to their employers, but that is otherwise lawful. I mean, imagine if you ran an animal rights organization and you had an employee whose hobby involved hunting. You might find that particularly offensive and want to fire that employee. Well, Colorado's law, providing that the hunting was lawful, would prevent that. Interestingly, the Capitol siege, the first question is, was the employee's conduct lawful? And we know a lot of people who were engaged in that were not engaged in lawful conduct and have been charged. But that is that's sort of a first point question. The next is, if it is lawful, what can you do about it? And again, New Jersey offers fewer protections. But with all of that, I have to come back to the NLRA, which is the National Labor Relations Act, which does offer additional protections. Now, I always point this out in this context to employers, because I often have employers who think that the National Labor Relations Act does not apply to them because it relates to labor organizations and unionized workforces. If you don't have a unionized workforce, they think that the National Labor Relations Act maybe doesn't apply to them. That is a misunderstanding of the scope of the National Labor Relations Act. The National Labor Relations Act, while it is primarily concerned with organized labor and unions, it also protects concerted action, the kind of conduct that is likely to lead to unionization or a concerted action by employees to band together to complain about the terms and conditions of their employment. So, for instance, a rally for a higher minimum wage could potentially be considered part of concerted action, and even though it's lawful off-duty conduct that is not otherwise protected under New Jersey law. So employers really need to weigh and consider how the NLRA may apply to each situation as well. This most frequently, I think, arises recently with employees complaining about the terms and conditions of their job and about their work situation on social media, which of course is troubling to employers. You know, it hurts their reputation, it hurts morale. Certainly, it's not the kind of conduct that employers want to see on social media. Yet at the same time, the National Labor Relations Board, which was created under the National Labor Relations Act, has viewed a lot of that conduct as protected. In other words, employees complaining about how they're treated at work publicly on social media to one another and to others can be the first step to forming a union. So employers really do need to tread carefully here on this legal off-duty conduct and understand how the legal off-duty conduct protections vary state by state. I mean, many people are surprised to know that there's a smokers' rights law in New Jersey or tobacco rights law. And you may be surprised if you're a multi-state operator what protections are available or are not available under various state laws. Moving on. I'll highlight some of the challenges of a remote workforce. We've talked a lot about, we started with COVID, we talked about how to handle cannabis in the workplace, which is changing the workplace substantially. And then obviously the off-duty conduct that we just touched on is changing it. But perhaps the most immediate concern right now for employers is, what do I do about a remote workforce? Do I maintain it? Do I start bringing people back? What have we lost by having people remote? Now, obviously, the answer is different for different organizations, but there are some significant considerations that I think employers need to weigh as they are legal considerations as they are considering what to do about their remote workforce, whether they're going to maintain it or maintaining even more flexibility. The first, obviously, is productivity. If employees are not as productive, I think having them work remotely will not last. And yet, at the same time, how do you monitor that productivity? That's going to be a particular issue because often in employment cases, and particularly when you are defending a discrimination case, you look for comparators, people who were treated, people whose performance was equal and were treated better. So being able to track productivity and have documented analysis of each employee's performance is important so that you can defend the actions you take in connection with an employee. And if you're not managing that productivity, you don't have records of it or records of the performance issues, you could potentially be leaving yourself open to liability. I'll point out here that New Jersey and many other states still has guidance, although it doesn't have the force of law, but guidance that employees should be permitted to work from home during the pandemic as much as that is practicable, which it sometimes is, sometimes isn't. And so I just point that out to people who want to know that and to understand that if you're going to require employees to be back in the office, you just need to make sure that you have a reason why it's practical. It's practical to have them back in the office. And I think for most jobs, there are reasons. There are productivity reasons. There are culture reasons. There are, people may be able to do 90, 95% in certain cases of their job remotely. but they can't do 100 in many cases. And, certain tasks have been falling down during this process. And, a lot of people have made do with remote work and done well, but that doesn't mean that you can't justify requiring people to come back to work and on the basis that it's not practical to maintain a fully remote workforce. The next issue that you really need to consider and develop policies around is data security. If employees are able to access sensitive, confidential information, either of your company or of your clients or your customers remotely, you need to take steps to make sure that data is secure from viruses, from infiltration, people in their homes. That's a really, really important step. I can tell you, even personally as an attorney, I always think when I leave the office, especially when we're in the office more often, if I'm going somewhere and I have to valet park, I can't bring confidential material and leave it in my car because I don't want to expose it to anybody. It's my client's particular confidential information. Maybe that's over the top, but I think you do need to think about data security in all of those ways. Safety. Safety is another issue too. Employers are, potentially liable for workers' comp injuries in the home. So employers should be thinking about ways to have policies to make sure that employees have safe places to work. We're not seeing a large increase in workers' comp claims coming out of people's homes yet, but it's certainly a factor that you need to consider. You also need to consider when and how accommodations are required and are necessary. The courts over the course of probably the last decade have changed their view. Originally, it was that working remotely wasn't sort of a default reasonable accommodation, which is required for people who have disabilities. Reasonable accommodations are, and working from home was not considered necessarily the default. Courts have now said, employers, you really need to come up with a reason why working from home, especially for office-based jobs, is not a reasonable accommodation. Because with all the advances in technology, working from home ordinarily for office-based jobs is a reasonable option. Again, only for people who have disabilities that prevent them from working in the office. Not necessarily for everybody. That can be a business decision. Training is a challenge of your remote workforce. There is a lot of training by osmosis, a lot of developing particular culture within an organization, and how you go about doing that is very different remotely and harder. You might be able to have formal training courses, but can you really conduct the same kind of training, and can you develop employees as quickly? I will suggest to you that one thing employers and employees themselves should be considering is, even if I have the option of working remotely, am I inhibiting my growth? Are we going to see a period of time where the people who stay at home are the people who are expendable in the event of a layoff, or the people who haven't grown as quickly into their careers? So I think that employees themselves have a self-interest in making themselves important in the workplace and finding ways to contribute the most they can. And some of that will be certainly an issue. And again, that ties into how do you establish and maintain the culture? Culture is really important, probably one of the most important things for having a productive workplace and cohesion. And I think that having a remote workforce has really become a challenge for maintaining and promoting that culture. I think we all push ourselves to work harder, seeing how our colleagues are working. I think there is a competitive nature to us that I think is really, really important. So before we move out of this, I do want to highlight, before we get to the question portion, I do want to highlight for you a couple of other issues that are coming down the pike. And we have a couple of minutes, so I'm just going to go through them quickly. But there are things that employers do need to keep in mind. One is, how are you going to return to work? Well, that interrelates to this remote workforce. But there have been a number of studies recently that have come out that reference how employees prefer to work. And I think employers do need to take into account, separate from what you can do legally, how that's going to affect the marketplace. You know, is offering flexibility a way to retain and attract talent? And are you going to potentially lose talent if you aren't offering the same kind of flexibility that your competitors are? So that's a little bit beyond the straight legal, but I think it's an important thing to consider. The next hot topic, and I have to highlight this, and I've been highlighting it for years, but it gets hotter every year, and that is our independent contractor versus employee issue. Um, as many of you know, in New Jersey adopted the ABC test for this issue. It's called ABC because there are three parts: Part A, Part B, Part C. But it is a New Jersey's ABC test, an application of that ABC test for my New Jersey employers is one of the most strict in the nation, although not the strictest. In California probably remains that way. But the department has taken a very strict look at who the Department of Labor will consider an employee versus an independent contractor. I don't always agree with their view on this, and in fact, the appellate division recently reversed the Department of Labor for being overly aggressive on a particular case. But it's important to know that we are looking at some potential legal changes to that. The Federal Department of Labor has proposed and now is reviewing a rule to change how independent contractors are classified. New Jersey had introduced but did not sign into law a change that would have made it harder to become an independent contractor. So I think the overall sort of 4-year trajectory of this particular issue is worth noting for employers, because I do expect that we're going to see a lot of pushback and a significant legislative effort to limit and close close the number of employees who are treated as independent contractors. It's a controversial issue because the government obviously wants to make sure that employees are not being taken advantage of. But in many industries, that's precisely how these businesses operate. There are tax advantages for being an independent contractor. There's freedom from that, and there are some employees that really are concerned that they'll lose opportunities if their independent contractor status is questioned. The government, on the other hand, is obviously looking to have fewer independent contractors, and so that just keep an eye on that issue as it evolves. We'll obviously be writing about it and keeping you updated, but I want to make sure everybody knows about it. And the final issue, just to keep an eye on, for those of you who use restrictive covenants, that would be non-competes, confidentiality agreements, non-solicitations. Those are also evolving and changing. There's been some proposed New Jersey law. It's not worth getting into the particulars right now because it has not passed. And I don't know that it does not look imminent that it will pass, but to limit the use of restrictive covenants, we've seen that in a number of states. We may also see some movement there at the federal level, although I think that's less likely. But you just need to keep up to date on those changes in the law to make sure that you are getting the protections you think you are getting and are drafting your non-competes and your non-solicits and your other restrictive covenants in a way that makes them most likely to be enforced. So with that, I want to open the floor to some questions now that everybody sort of has a view as to where things are going and what's going on. And feel free to unmute yourself or put questions in the chat, whatever's most comfortable for you. And if you don't have questions and you're thinking about leaving, I just want to thank you for attending before you leave. Remind you to email marketing@flastergreenberg.com if you have any questions or would like a copy of the slideshow. Or you need credit, we'll certainly take care of that. And if you have any other questions or concerns, or please feel free to email marketing@flastergreenberg.com or contact me directly. So I thank you all for attending, and I welcome any comments or questions you may have. Yeah, two really good questions. So Maureen Blum asked, can we poll employees to see if they've been vaccinated to determine our return policy? Maureen, I'm comfortable that you can do that. What you ought not do is ask people who have not been vaccinated why. You can certainly ask people whether they've been vaccinated and or whether, and if they have not, whether they intend to be vaccinated. I do recommend that you stay away from asking the question why. That's an excellent question. And Kim Riley asked a question. Any new guidelines on protection for workers that regulate and use machinery and heavy equipment in regards to cannabis use? Kim, I'm really glad you brought that topic up as well. That I mentioned, I think at the outset that, you know, I was going to explain to you what the cannabis rules were and talk to you about some potential changes. The cleanup, I referred to, I think, as cleanup legislation, which is how it's been referred to. And certainly industry is pushing for some additional guidelines, Kim, specifically for employees in safe, you know, truck drivers and people who operate heavy machinery, more safety related exemptions. It does not provide for that. Only the federal contractor exemption. But there's certainly been a push for that. I think that there will be an effort to put that into place. I think, you know, given how difficult of a time New Jersey had in coming to an agreement, even after it was passed, you know, by the voters in coming up with a cannabis law, I think it's going to take some time. This has really been a lot of stops and starts on that issue. So I think it's an important concern. Right now, I think you've really got to look for impairment at work, obviously, when people are using heavy equipment and things like that. But you can't treat them any differently than an office employee. So thanks for asking the question. And then Lori asked a question. My staff's 100% vaccinated and I'm looking to hire to protect my staff. Can I ask on applications if they have been or going to be? And what if they come back and say, I didn't hire them due to non-vaccination? Or that is another really good question. I always love the questions I get from these. And I do have some concerns about that approach here. I think you should consult with counsel. The concern would be that you would be eliminating people who either have a certain deeply held religious belief, if you're not hiring people who aren't vaccinated, or people who have a certain medical condition. And that in fact could be troubling. So I think you've got to find a way to at least screen or think about screening without potentially engaging in that hot button issue. So I'm glad you raised that question. I'm sure it's probably on the minds of others as well. Good question. Now that CDC, Carol Washington asked, now that the CDC is easing restrictions on masks for vaccination indoors, they're considering having employees wear a small ribbon. Do you see this as any issue with this approach? Carol, that's a very interesting question that I actually got yesterday. And I do see an issue if you are requiring people to identify as vaccinated. And particularly the concern I see there is the potential for somebody to say, I felt singled out, my workplace became hostile because I couldn't get vaccinated due to a deeply held religious belief. So I think that can be an issue. At the same time, encouraging people, passing out buttons, allowing people to wear them would be fine. But I think certainly any kind of, you know, requiring it or putting any kind of heavy hand on the scale, thumb on the scale of that one, Carol, I would stay away from in that situation, specifically because we do have people who are protected, and it could potentially lead to a discrimination claim. So I think you got to tread a little cautiously on that one. But that isn't to say that people who want to wear stickers that they were vaccinated or have ribbons or do whatever they want, if you want to make those available to people, that they can opt to do that. That's a different story than requiring it. Let's see if there's any other questions.
Adam?
Yes.
I have a question. I was starting to type this in chat and it's just too long. This is
Sure.
Jennifer Adams from Converge. My question involves cannabis and workers whose positions are either safety sensitive or who are regulated by a federal agency like Department of Transportation, whom have to be they need their drug tests are going to be illegal for marijuana because they're by the federal mandate. If they're working in a position that does have to go by the federal mandate, but they live in a state like Pennsylvania where they have a medicinal card for marijuana, it's okay for the employer to have a policy that states those positions that are, you know, safety sensitive or regulated by federal mandates will have to, you know, the federal mandate will apply to them in terms of marijuana being illegal. That is a lawful practice, correct?
So certainly in Pennsylvania it is. In New Jersey, it's a little more complicated, and particularly, I'll say that the DOT issue has been raised repeatedly. People said, well, wait a second, you know, DOT says I've got to have a clean drug test for these employees. How can I continue to operate? And the New Jersey law simply says, you know, you don't have to accommodate medical marijuana use if you're going to lose a federal contract. Well, not all DOT drivers have federal contracts. So that is a complicated issue, and an issue that I do expect to be resolved by the law. Again, here interestingly, an employer who terminates or disciplines or suspends an employee who tests positive for cannabis use on a DOT test isn't suspending the employee, I would argue. Because the employee used cannabis, they're suspending the employee because the employee is no longer eligible to be a license holder. And that is a requirement of the job, to be a license holder. You don't set the license requirements, the Department of Transportation does. So I think that that's an important nuance and a protective nuance in that circumstance in New Jersey. In Pennsylvania, it's really you know, it's like New Jersey was. So you have a lot more options in Pennsylvania and other states. But the New Jersey law is really quite broad, and I think, you know, you've got to, as an employer, focus not on that this is discipline or termination from cannabis use. It's really, you're not qualified to do the job if you're not a license holder. Just like if somebody gets their license suspended or anything else, you know, you're not judging somebody for being a speeder necessarily, but they can't do a job if they don't have if they can't maintain a license. So I hope that's helpful. I do expect some changes. I mentioned, to Kim's question, I do expect some safety related changes. In particular, I think the biggest one we'll see is some exemption for the DOT. I'm surprised it wasn't in there, but again, this was such a messy process that I think there is some cleanup required. As some of you may even know, originally the law said that if a minor was caught using cannabis, the police officer wasn't allowed to notify their parents. They had to give them a warning, but you couldn't tell their parents. That has since been changed, and now the officer is supposed to tell the parents, which as a parent of teenagers, I'm very happy to hear. I don't know what they're up to. So I do, we've already seen some cleanup legislation go through, and I expect to see some more pretty quickly. Lorraine asked a question, which is really interesting. Does the CDC guidance or New Jersey executive order take precedence on masking guidelines for New Jersey employees? Lorraine, actually, the executive order incorporates the CDC guidance. So it says, you know, the employers should follow the CDC guidelines in terms, at least in terms of quarantining and those requirements. To the extent that there's a conflict, I think you do have to look at the New Jersey executive order. So while it does incorporate the CDC guidelines, it also does say that employees should be masked unless they can be socially distanced in the workplace. And I would follow those at this time. I do expect that New Jersey, they've been consistently adjusting in accordance with the CDC. So I expect that'll happen. But to the extent you have a conflict, I would follow the New Jersey executive order over the CDC guidelines, with the understanding, however, that in many of the aspects of that executive order, particularly, Governor Murphy incorporated CDC guidance and said you should do what the CDC tells you to do. Debbie Pino asks, when reopening, can we require all employees to return to the office? So with the understanding that it depends a little bit on when you reopen, right? New Jersey, as I mentioned before, still maintains the guidance that if work can be practically done at home, employers should allow people to work remotely. So the first question I would ask you is, do you have employees who can do 100% of their job from home? If you do, I think you need to weigh that more heavily. If you think that there's some aspect of the job that cannot be done at home, then I think you can require employees to return to the office. Whether it's all employees or you have to stagger it, really depends on the level of social distancing you can maintain in your particular office space. Many employers are using an alternating A/B kind of schedule, or 1-2, or every other day, or things like that, to space people out. I think that's important, depending on how much space you have, whether people have their offices with doors or not. So a lot of that becomes very fact specific. I will tell you though that there was some research published this morning actually that I was reading on this topic that I thought was particularly interesting, and the discussion was really around the fact that employees are experiencing trauma and shock from the pandemic, and that employers would be well served to be sensitive to easing them back into the workplace, even if it's legally allowable and in the company's best interest. We should be sensitive, and it would benefit the employer to be sensitive that people are experiencing some degree of trauma, and it will take just some easing to get back into the flow of things. So I offer you that as some practical and non-legal advice to consider. With that, I see we are going a little over, but I've got one more question. So let me see what I can do here to try to address these quickly. The first is from Maureen Bloom. If employees do not want to work with unvaccinated employees, what do we do? Polls have shown 75% of employees don't want to work with unvaccinated employees. You really need to be careful here, Maureen, because employee choice on this topic is really not that important. Imagine that you had a group of employees that said we don't want to work with somebody of a certain religion or a certain color. You couldn't make that determination, and in this case, certain unvaccinated employees fall within a protected class, whether it's because of their religion or their health condition. So you really do need to be cautious and careful. There are opportunities to allow unvaccinated workers or require them to continue working from home if it doesn't hurt their terms and conditions of their employment. Many employers are rightfully resistant to doing that out of fear that employees who want to work from home will just not get vaccinated or say they are not vaccinated to maintain the ability to work from home, which an employer also doesn't want. So it's a balancing act, but I think you got to be cautious and maintain control, even though you have employees who say we don't want to work with somebody who's unvaccinated. In addition, I think the science is starting to show that those of us who are vaccinated are not at much risk from those who are unvaccinated. Once you yourself are vaccinated, it doesn't present that same level of risk, hopefully. And then Lori asked for the COVID leave again expiration. I think you want to know, I think your question is really, the required COVID leave ended at the end of 2020. You can now in 2021 offer additional leave. It's optional. It applies to, and you get a tax credit through September 30th, 2021. And again, that only applies to employers with 500 or fewer employees. So with that, I think we've gone a little bit over, and I don't want to keep anybody, although I will hang on the line in case somebody has any questions. But I thank everybody else for joining, and I hope you found this informative. I hope if you like the slides, remember to email marketing@flastergreenberg.com, and I certainly look forward to talking to you more as new developments come out, which I am sure they will. So thanks, everybody. Molly and Krista, thank you so much. Hey, Molly. Hey, Krista, can you hear me? It's just us now. Molly, Krista? It's been on mute. Oh, maybe you left. All right. Well, thank you guys. If you can hear me, I just want to say thanks. Good job.
I gotta go back. How do I go back?